And now we come into a very interesting part, and that is drug testing a search? And that has something to do with the Fourth Amendment of the Constitution. And remember, again, the Constitution is protecting the individual against government and not against a private company. So, for example, a search and seizure is an absolute right against government, but not necessarily against a private employer. The definition of the right of privacy is the freedom from unreasonable intrusion into one's private life. Unreasonable. Now you have to remember now that many years ago, 20 years ago, before technology was at the use that we have today, for anyone to do any, for government to do any research or any search on our body or on our car, on our home, they didn't have all the technology that we have today. So that the search had a tendency to be more unreasonable, where because of technology, just getting blood and urine from our body, it's nothing comparing what it used to be. So just remember that. Yeah, unreasonable intrusion into one's private life. Unreasonable intrusion into one's private life. What is a search? According to the Fourth Amendment, according to our Constitution, a search is a governmental intrusion upon expectation of privacy recognized by society at large. Not recognized by the individual, recognized by society at large. Governmental intrusion. And this is something very important because more and more we as a society are leaning toward the belief that the means justifies the end. We want to stop crimes. We do not want to be attacked. We want to be free to walk in the street, which I understand that very, very well. We want to be free to express our idea. However, not if it's hurting someone else. That's why we have political correctness. And the thing that is very, very interesting in our society, where we are so diverse, and everybody comes here to this country because they can practice their culture, they can practice their religion, their costumes, they can even wear the clothes of their tradition. They don't have to, quote, become Americanized, if you want to say that way. It's very interesting that the search is a governmental intrusion upon expectation of privacy recognized by society at large. We have a lot of problem in that area because we try to enforce the prevailing culture, or we try to enforce by law what society at large expect. We need some kind of a standard of expectation so that we know how to relate to each other. And when we are finding out, for example, that we're going to have more immigrants or illegal immigrants, or even just immigrants than black people, we decided to change the immigration law so that it will be more difficult for the people to come to this country. Again, the balance, yes, everybody's free to come here because this is the best country. With all the faults we have, this is still the best country. However, what's going on if we're going to have more people of other cultures and not enough of the prevailing culture that made this country and this society what it is? Do we want to disappear completely as a society, as the United States? And this is where I want you to really give it a thought, because the expectation of privacy that is recognized by the society at large, or the reasonable people. Is drug testing a search? And if so, is it reasonable? The textbook does not mention much about the history of drug testing, but the first drug testing was done by an employer that was public, a government. And the employer had reasonable suspicion that the guy was taking drugs. And therefore, they had him tested, and they find out that he was taking drugs. And of course, the first case, then definitely the court said that was a search. And then if the court, if the employer had reasonable suspicion that he was taking drugs, then they could do the search, but the search had to be reasonable. And of course, in this situation, it was not reasonable. What they did is he was on vacation, and they asked him to, they came over to the place where he was vacationing, and they asked him to, give him some urine. And then they went back to the lab, and they found out that he was on his vacation, that he was taking drugs. So one of the reasons that I want you to know is, again, what is the reasonable people expect? And you see today that we do expect, when we go for an interview as an applicant, don't be surprised that you have to take the test. And if your test is positive, you will not get the job. That's a term and condition. And why the court says that that's okay is because if you don't want it, take the test. You can go to another company. And it's not necessarily true as much today because almost every applicant have to take the test. Small company still does not require that, but especially big company, Roche and Merck, and you have to do it, period. And sometimes I can see with pharmaceutical company because the temptation might be there to take drugs, but I don't understand why, for banks. But again, it's much more acceptable behavior. The reason people, why? Because nobody wants to deal with people that are taking illegal drugs because of their behavior. Maybe, one morning they get up and they go around shooting people, and we don't want that. The question that I have is, if alcohol abuse is much more likely to endanger the public than drug abuse, and alcohol is twice as costly to society and twice as many adults are alcoholic as drug addicts, then how come we have drug testing only? And the reason why I'm saying this is because there is a survey, and this survey is pretty much consistent, where there are 7,000 deaths from overdose of homicide were related to illicit drugs. So every year about 7,000 deaths we have that are related to people that are taking illegal drugs. However, we have 200,000 deaths attributable to alcohol, domestic violence, children, women, people, in the subways cases where they were driving under the influence of alcohol, a lot more death because of that. And so my question is again, how far does an employer can go in invading employees' privacy rights in the interest of worker safety and efficiency? For example, the employer has a reasonable suspicion because he believes in good faith that you might be smoking marijuana, and is asking another employee that he trusts to invite you to see the Super Bowl, or for you to go and visit him at his home to watch the Super Bowl, so that you can find out what his behavior. So you become friend of this employee that there is reasonable suspicion that he's doing something illegal. And it's okay because the employer asks you to do something that he's responsible for the worker safety, and you yourself believe that you don't want to have an employee there that does anything that it's illegal. I received a phone call for someone that he said there was an employee that came over to his office, and he's a manager, and he says such and such a person is taking drugs. And now, is just rumors? Is there something that maybe this employee told something to the manager because he hates the guy so that the guy will be suspended? Because if the manager goes face to face with this person that there are rumors that he's taking drugs, the company, and he can be sued for defamation, because I'm sure that the guy is going to say, I don't take drugs. I never heard anybody yet that was confronted of doing something wrong that says, yes, I did it. You want to know how? Usually they say, I'm not guilty. And the law says you're innocent until proven guilty by your peers, not even, by your employees or employer. So these are the things that I want you to be very careful, because how far can an employer go? I know situation that I was in court that really made me feel uncomfortable, where a town would hire high school children or high school kids to go to a deli or to go to a small candy store or whatever to buy a cigarette. And the person in the back would give them the cigarette, and then they would be arrested. And it's a pretty steep fine for the owner of the store and the person that works behind the desk or the table, I guess. And so, but what are we doing here? We are saying it's okay to ask teenagers to buy cigarette so that then the people that are selling to minors can be arrested. The means justifies the end. And that is pretty scary because, yes, we do want to discourage young people from smoking now that we know that cigarette may, not shall, cause cancer, because I know that there are people that smokes their head off and they never cause cancer. And I know my father never smoked, and he, for a while, they thought he had lung cancer. He didn't, what he went through to find out if he had that, even if he did not smoke. But it's one of the situations that I want you to be careful. How far can an employer go invading employees' privacy rights in the interest of the worker safety and efficiency? Because sometimes that might be used just to terminate you and not necessarily because of the work safety and efficiency. And then the next question I have, what is safety-related position? What is a safety-related position? And again, we have no definition, and it's really very subjective. Critical questioning with the increase of trauma, disorder, disability claims filed by employees. Will OSHA closely regulate a place of employment? From what ethical perspective? What public policy here? And I know that there are situations that because of trauma, disorder, disability claims, more and more companies are allowed, or even insurance company for that matter, like workers' comp, they are allowed to videotape your house, the front of your house, the back of your house. They're allowed to, and that evidence can come in. Even if many years ago the evidence would not come in because the insurance company is a third party, has nothing to do with the relationship between the employer and the employee. Very interesting. And again, will OSHA, federal law, and I know that OSHA has a responsibility to do research, and I know that OSHA would send out memos to companies, for example, you know, which company has #1 of colon cancer. I know New Jersey has pretty high colon cancer percentage, and the companies in New Jersey are much more responsible than to have the employees tested for colon cancer because of that. And again, for the good of society, for the safety of other employees, because again, they're paying for a benefit. But then, if this is necessary, how far then can the employer find out about us? Did your mother and father die of cancer or colon cancer? Did your sister? I mean, these are the things that I want you to really think about it. Here's another case that I thought that was very interesting to share with you. And the reason why I'm sharing these cases is because they were decided the same year, opposite. And it depends on the issue, how you ask the questions. And this is why I'm teaching you this, because when you are going to present an issue and you want to say, hey, I have a right to do this, you have to be careful who you're comparing this right to. Very important. So here is a situation where 3 related discharged cases were taken to a grievance arbitration. Now, #1, this is an arbitration case and not a court case. And that means in arbitration, if you don't remember, or you forgot, or I forgot to say anything, arbitration, hearsay can come in, ethics can come in. In a court of law, you only argue law. In arbitration, it's a whole different thing. And of course, the arbitrator does not have to be a lawyer. Often they are former judges or former lawyers. And sometimes they have to be skilled in the labor. In this situation was a labor situation, so it had to be something to do with labor. The 3 employees had, while on the job, used drugs. they lied about such a use in the grievance procedure. Of course, they're not going to say, have you been taking drugs? And he's not going to say, oh yeah, you want to know which one and how many? Nobody. Everybody's going to say, no, I did not do it. They contended that in the history of the company, no one had been discharged for a first offense of alcohol use. So here they're comparing illicit drugs to alcohol use. Why? Somehow alcohol is acceptable behavior. Yet, it's we are, one of the things that I sometimes get very annoyed is that there are much more car accidents that you are driving, not because you're under the influence of alcohol. However, if you're driving and cause an accident under the influence of alcohol, you're dead. But then if we have more car accidents driving not under the influence of alcohol, then why don't we stop that instead of picking on something that we have less accidents? Again, what we're trying to do as a society, are we trying to control behavior, or are we really trying to control safety? So here is a situation where they say, for somebody that uses first offense of alcohol, as a matter of fact, the employer has a duty to what? To send you to rehabilitation so that you stop drinking and go back to work. The issue in this case was, is the imposition of discharge for the first drug offense proper under the just cause? And of course, being that it was a union, they had an agreement that the employer can only terminate you for a just cause. And in this situation, it says, is it just for us to be terminated for the first offense of using drugs when you have a first offense of alcohol, you not get terminated? And of course, the judge says no. Now remember, he's comparing drug use with alcohol. He's comparing a behavior that with alcohol, first offense, it's okay, but not with drug. And I like the way this judge decided. He says this discharge is not a just cause discipline for a first offense of drug use. Alcoholism, although legal, and you know that is legal, except if you're under 18 or 21, I should say now, present a more destructive element to a person and employment than casual drug use. And you saw that from the survey before. There's a lot of more death attributable to use of alcohol than illicit drugs. He continues to say, to allow discharge for drug use where it would not be imposed for alcoholism is clearly improper. It's not proper to terminate somebody for first offense for drug use, but not alcohol, when with alcohol it's more damaging to society than the drugs. Just cause did not exist for discharge. Therefore, the employee has to be reinstated. And they were, without loss of seniority, but because they lied during the grievance process, they were not awarded back pay, but they were be able to reinstate, because this is a union agreement that's out. In a regular company without a union agreement, this wouldn't have happened. The other case that was decided the same day, and I just want you to see the difference, because it's very important the way you present your issue, if you want to, or the way you present your questions, if you want people to answer the way you want to. And we learn how to ask questions. For example, you don't ask direct examination because then the answer is yes or no. And in cross-examination, we're going to ask in a different way so that you will answer yes. Do you believe that more and more people in our society are accepting the same-sex gender? And you're thinking, yeah, I believe that because I see more and more people doing it. And right away then and there, the statistic will show that, well, more people in our society is accepting that kind of behavior. However, if they would ask you, how would you like, for example, being that I have sons, how would you like your son to come home and introduce you to to his fiancée? I don't know. I don't think I would say, yeah, that's more acceptable, because I don't know if I'm ready to accept that kind of behavior. I like to think that I love it no matter what, but I don't know. I really do not know. And this is where it's very important how you ask the question. In this case, an employee was placed on an indefinite suspension and subsequently discharged for smoking marijuana on company's property. Such act was both a violation of the law, which we know, it's illegal, and also a violation of the work rule. The union filed a grievance contending that discharge was not justified as the employee was not advised of the work rule. Okay, one of the first things that you get a lot of memos in your companies and you're advised of the work rule, and many times they ask you to sign things. Well, if you do not sign, that means what? You do not consent into that work rule. And therefore, if something does happen, then you did not know about the work rule because you did not sign the work rule. Here is something that he's saying, I was not advised of the work rule. I did not know it even existed. He did not know that he was not supposed to smoke marijuana at work. He had a clear work record, and his action did not adversely affect the company business. And as a matter of fact, he did a good job. Maybe because he smoked marijuana, he was a better employee. I don't know. But that's the reasoning that the union presented. The issue, now this is the question. May an employer justifiably discharge an employee for violation of a work rule? You see that? There's a work rule now. What do you think the court's going to say? Oh, that's a stupid work rule? No, the court will not say that because it will not interfere how a business or a corporation rules. I mean, just like they don't interfere in families' rules. Like I used to have rules. I used to have, midnight, they had to be home. At a certain age, they could be home at 1 o'clock. Nobody's going to interfere with those rules. So, again, the judges are not business people. They don't want to interfere the way company are run. So if a company has a rule, they're not going to say, hey, you have to change your rule. But if you violated a rule, then something has to be done here. And of course, you see that the judge says, yes, an employer can terminate an employee if he violated a work rule. If those are the rules of the company, that's it. So yes, violation of the law as well. Not only did he violate work rule, but he also violated the law, which is secondary. Employee was aware because it's also violation of the law. So not only can employer discharge him because he violated a work rule, and the fact that he did not know that was a work rule, the judges don't give me that because that, it's also a violation of the law. So you pretty much knew that it could also be a violation of a work rule. It is not relevant whether the action adversely affected the company business. It's nothing to do with it. If they're going to have a work rule, it's nothing to do with that by him working in the company, they were making less profit. It has something to do that's the company work rule, and therefore you have to be submissive to the work rule. The employee violated a rule establishing order in the workplace. He was only 11 months now. This is another important thing. It was only 11 months there with the company, and therefore discharge is justified. The question is, if he was there longer than 11 months, if he was there 5, 6 years, would the company also discharge him? I would say that if the issue was that he disobeyed a work rule, yes, no matter how long you work with the company, violation of a work rule, the employer is justified in terminating the person. Privacy in the digital age. This is where you and I are very much now going, and there's no way of stopping it. And the following case, I find it very interesting for you to read. It's something to do with military service. I'd like you to read the case. I will post it on the discussion board. I would like you to read the district court judge memorandum, because you're going to see. And it was a chat room, and it was a behavior that it was not acceptable. And after you're going to read this case, I'd like you to discuss the different ethical perspective that led the judge in making the rule. And of course, I'd like you to post your legal and ethical perspective. And because of this case also, I'm going to post another case that has an opposite decision. Again, reflecting the prevailing culture, ethical perspective, and society, and what is the reasonable people expect the court to decide. Thank you.